I now call the meeting of the Code Enforcement Magistrate to order. Please stand for the Pledge of Allegiance. Welcome to Hillsborough County Code Enforcement Special Magistrate hearing. When addressing the special magistrate, please state your name, address, and speak clearly into the microphone. If you're planning to speak during the hearing, you must have signed in the speakers list, which was located at the front door. The basic procedure for the hearing is as follows. Ms. Meyer will conduct the oath of witness. Your case will be announced. Officers will present the evidence of your case. You will be allowed to rebut the evidence and explain what has occurred. I will close the hearing and announce a decision. I may ask questions and allow other witness testimony. If you have not complied with paying the past due citation penalty, fines, or correction, the original violation. By law, you have 30 days from the date of the order to appeal the decision to circuit court under Florida Statute 16211. Any person who decides to appeal the special magistrate and/or hearing officer's decision will need a record of the proceedings. The proceedings will comprise of the testimony and evidence upon which the appeal is based. It is your responsibility to ensure a verbatim record of the proceeding is made. By law, you have 30 days from the date of my order to appeal any decision to circuit court. Presentations by the county respondent or respondents in opposition must be kept to a maximum of 10 minutes each. The special magistrate and/or hearing officer may recess at 12:30 and reconvene at 1:30 to conduct business if needed. If you have any questions, these rules are outlined in Hillsborough County Code of Ordinances and Laws, Chapter 14, Article 2, Section 14. At this time, please silence all electronic devices. First case.
Okay, all county staff who is going to testify must take the oath of witness. Please stand and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. First case is on the vehicle for hire agenda, page 2, number 1, case number RCV 2101280. And someone is present. No one is present to speak on this, right? Okay. So I will turn it over now to the officer.
Okay, officer, go ahead.
Morning, sir. My name is Alan Grinaldi. I'm an investigator with Hillsborough County Regulatory Compliance. I'd like to note one correction before I begin. On my citation, I wrote an incorrect date in the narrative section description of the offense. I wrote 8/8 of 21. It should reflect 8/8 of 2020. I received this complaint in February of this year. The gentleman's car was towed. He had a number of complaints associated with his initial complaint. Unfortunately, only one of the items fell within the scope of our investigation and was actually covered under the ordinance, and that was the tow company's demand for cash payment for the release of his vehicle. They failed to accept an alternate form of payment, whether it be credit or debit card, and the complainant, who is an attorney, provided a 61-page brief outlining his full complaint, which I believe is a section of that addressing this violation is on page 4. This is actually Cindy Anderson's PowerPoint.
Okay, is the car still an impound or
No,
has
sir.
it been released?
Owner retrieved his car the day that it was impounded.
Okay.
That's the correct PowerPoint now.
Yes, ma'am. If you go to page 3 on the PowerPoint, it's actually a snippet of that 61-page brief written by the complainant that outlines his requirement by the company for him to pay cash for the release of his vehicle. And subsequently, I issued the citation for that charge.
Okay, did the complainant incur any other charges because of this?
No, sir.
Okay.
We'll add that there was a additional case from the same company where a complainant was required to pay cash to pick up the vehicle, which was a violation. However, that particular case did not come to hearing and it was resolved without any citations being issued. Just wanted to mention it because it does show a pattern of behavior by this particular tow company. I have the case number on that one if you'd like it.
Okay, I won't need the case number. Anybody else have anything they need to say? Okay, I'm ready to make my ruling. Is this the citation number here, the CRCV?
No, sir, the citation number is 00728.
Okay, I see it there. I rule in citation 00728. Based on the evidence presented, the violator has failed to pay the fine penalty that was imposed by the county ordinance, Chapter 10, Article 16, vehicle for hire. Order violator to pay the penalty fine of, it was $50, correct?
Yes, sir.
Plus an administrative cost of $100. The total fine being $150. This must be paid within 7 days of this order. It does not mean that you are in compliance with Chapter 10. You will need to correct the original violation that is noted and corrective issue to be resolved. Failure to comply with this order within the specific time set forth with the above results of the above will also result in the suspension of the license, permit, and or certifications. Next case, please.
Mr. Bernero. Mr. Bernero, this is Paul Johnston with the County Attorney's Office, if I may.
Who's saying that?
Stand by. Can you please identify yourself?
This is Paul Johnston with the Hillsborough County Attorney's Office. I just wanted to make a correction. That would be Chapter 50, not Chapter 10 of the county ordinance.
Counselor, I don't understand what you're doing.
I believe you recited Chapter 10, Article 16 of the county ordinance. The actual citation on it should be Chapter 50, Article 7, Section 50-177D.
So you believe that this should be under Chapter 10?
No, it's Chapter 50.
Chapter 50.
Yes, sir.
At the advice of counsel, we will change it to Chapter 50. What about the article, sir?
Article 7, and it will be Section 50-177, subparagraph D.
Okay, staff, got that? Okay.
It is listed on your.
Thank you.
Okay, thank you, sir. Anything else? I guess he doesn't. Next case.
Next case is number B, case number RCV 210074, citation 00831. And no one is here to testify that the officer is here.
Okay, go ahead.
Cindy Anderson, Regulatory Compliance, 2709 East Hannah Avenue. I received the complaint on on January 4th. The consumer's car had been towed from her driveway. I reviewed the consumer supporting documents, sent over the business via email on 2 occasions, and then hand-delivered the complaint as well as a letter giving 10 days to respond in writing with the supporting documents that are required. Per Section 50-190J, I received an email from the owner of the business acknowledging the receipt of the complaint, though I never received the supporting documents. 4 weeks later, after not hearing from the business or receiving the required documents, I issued a citation to the business for failure to cooperate. There were potentially 4 other citations that could have been issued, though I used discretion and only issued the one for failure to cooperate.
Okay, anybody else have anything to say on this matter? I'm ready to rule. This time we'll try and get it right. I rule in citation 00831. Based on the evidence presented, the violator has failed to pay the citation penalty fine imposed by the county ordinance chapter 50, article 7, trespass towing. I order the violator to pay the citation penalty fine of $50 and an administrative cost of $50, the total being $100. This must be paid within 7 days of the date of the order of the citation. The fine and administrative cost alone does not mean you're in compliance with Chapter 50, Article 7. You will need to correct the original violation that is noted on the citation for the issue to be resolved. Fail to comply with the order within the specific time set forth. The above also result in the suspension of license, permits, and/or certificates. And that's my order.
And thank you. That concludes the vehicle for hire section. And we will now go to the water resources, false alarm, and landscaping agenda. Turn to page 2, number 4, case number L195753. The owner is Baby A. McKill, location 3108 John Moore Road, and this is a contest of the finding of noncompliance by staff. And someone is present for this. If you're here for this case, please come forward now. Are you here for this case? Go to the podium. I can't hear you.
Thank you. I'm the owner of the home at 103 Craft Road. My name is Michelle Noeza, and this construction has been impacting my home.
Oh, okay. Hold on just a minute. Is anyone here representing the owners of the property? Oh, I apologize. The owners were here and they have left. He's going to rule and then you'll get an opportunity later to.
Okay. I rule on case number L195753 that this case be continued until
August 6th.
August the 6th.
I'm not quite sure I understand what you mean.
The case is being continued to the next hearing.
Yes, ma'am.
Mr. Bordenero is not the magistrate who made the original order, and it needs to be ruled on by that magistrate who will be here at that hearing.
All right,
So a decision is not going to be made today on it.
August 6th?
Yes,
Thank you, ma'am. I appreciate
thank
it.
you.
Okay, next case.
Number 5, case number L205996. The owner is Eduardo A. Dermosen, 5207 Nashville Drive. We have service and we have someone virtual for this case. Just a moment.
Eduardo, can you hear us?
Yes, well, Eduardo is here.
Okay, the people who are virtual, I need to have them on the screen so that I can give the oath of witness. Are they? Okay. Raise your right hand, please, if you're going to testify. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, and did you both state your names just now? Just go ahead and state your name and address for the record.
Eduardo
please.
Dermosen, 5207 Nashville Drive, Tampa, Florida, 33624.
Thank you. And the other gentleman?
Edward Garcia, 5207 Nashville Drive, 33624 Tampa, Florida.
Thank you.
Okay, Ms. Hall.
Go. This is Krista Hull with the Development Services Department. I'm the Environmental Supervisor. This is case L206596. Property owner violator Eduardo Dermosen. Violation address is 5207 Nashville Drive, Tampa. Violation observed is unpermitted removal of one laurel oak tree measuring 43 inches in diameter at 4.5 feet above the existing grade. Ordinance violated is section 4.01.03. First inspection, April 2nd, 2020. First notice, October 2020. Last inspection was June 7th, 2021. 3 inspections. First inspection on April the 2nd, done by Wayne Doyen, identified the tree had been removed of all limbs. Subsequent inspections show that Wayne identified the tree had been fully removed on April 5th. And the ground, there has been no restoration of any trees back on the property as of June 7th, 2021. The county's recommendation is that Mr. Dermosen submit a compliant tree restoration and/or contribution agreement for 43 dB inches to the Development Services Department and complete the county restoration agreement and/or contribution to the Restoration Fund within 60 calendar days. Fines will be issued for failure to meet the time frame, and the fund requirement is at $65 per inch.
Okay, which one of you wishes to speak first?
I would like to let my son to speak for me because he speaks very English than me.
So it'll be me, Your Honor. So the case in point was that my father was under the impression that a company by the name of Palms and More and a gentleman named Shane Rippey and his wife Jolene Smith were licensed arborists because they gave my father information on stating that they were allowed to remove his tree. Now, as you know, in the state of Florida, you're allowed to remove a tree. You just need a licensed arborist. And I understand that a code enforcement officer came due to a report The report was never made correctly. The report wasn't made on 5207 Nashville Drive. The report was made as an investigation to the company by a local neighbor. She called for Mr. Wayne to investigate why Palms and More was going around the neighborhood doing work, because this was not the only job that they were doing. If you looked into the other neighbors, there are other trees removed. And I ask, when Mr. Wayne came to our neighborhood, his investigation wasn't into our property. His investigation was into the property of the company. And my father was very confused because he was led astray into believing that Shane Rippey had licensing. He gave a receipt to the code enforcement officer saying that he was doing this legitimate. And the code enforcement officer didn't further in the investigation into any other house or the neighborhood when the original complaint was made towards the company. Because my father employed this company to work on his tree, and it was half done, and then the work was abandoned. The man left multiple tree limbs. He left his trailer out onto the street, and that is why code enforcement was called in the first place. Recently, I was informed as well that code enforcement officer, Mr. Wayne, also spoke to the original person who made the complaint on the investigation. This was stated that the code enforcement officer was informed that the 5207 Nashville Drive was never to be called on. The code enforcement officer also stated that he is familiar with this company and that this is something that isn't new. So my father is just questioning the violation placed on him was wrongly put due to the fact that he was never called on for a violation or code enforcement to come to his house. The investigation wasn't continued, wasn't further into the neighborhood, and nor was the code enforcement officer willing to speak to the actual person who called in because he was stated that he couldn't talk to him or talk to her. So we're honestly just confused because we've given all the information that we need to give to you guys, and we were led astray. A job was abandoned, and the tree was damaging the property. And we wanted to make an investigation.
Company to finish the job.
And he called another company to finish the procedure, and he can give you the name of the company. And the investigation was never to the home or property. This investigation was to the company as to why did it get abandoned and why is someone who is not licensed working on the neighborhood, which is Country Village. And that is all.
Okay, so you don't have, excuse me, you don't have anything to show me that these people told you, the code enforcement told you that you could cut this tree down, correct?
I gave to the code enforcement guy the receipt that he gave me.
The code enforcement, Mr. Wayne, apparently has a receipt given to my father for the purchase that this can be done properly.
Hello, sir.
Yes.
This is Wayne Dorian, Hillsborough County Environmental Code. How this process works is I got a complaint from my admin staff, which was called in from one of the neighbors as a tree violation at this property. That's what the complaint says. I did talk to the complainant that next day, and she explained to me she did not want to call in on Mr. Jamosin, but she did want to say about the tree company was cutting down the tree and didn't get a permit. Unfortunately, when I investigated, I could not find the tree company. I could not find a mailing address for the tree company, and I could not locate the tree company. And I've been doing investigations a long time. I did investigate other properties. There was one other property that had a tree removed, and they did have a certified arborist report, which falls under House Bill 1159. Mr. Jamosin did get played by these tree companies. They said and it's going on a lot lately. These small tree companies come in, they say, yes, the House bill, you don't need a permit, but they don't say anything about needing a certified arborist report and showing proof if asked upon. Mr. Jamosin did give me receipts, what he paid them. No permission was given from the county or anyone else. He did get played, as I put it, from the tree company, and the tree was taken down, which he thought they had everything properly done, which they didn't. I talked to the complainant again, the complainant that called it in again yesterday. She is an elderly woman and couldn't make it. And she tried to clarify, she just wanted the tree company investigated, which I have a lot of tree companies I'm trying to investigate and I can't find. So per the code, we have to cite the property owner, and that's where we're at today.
Okay, thank you, sir. Anybody have anything else to say? Okay. I'm ready to make my ruling. I rule in case number L205996 that you are in violation of Hillsborough County Codes or ordinances as listed in staff's presentation. A further order that I agree with staff's presentation where you submit I can't read the whole thing, the tree restoration and or combination agreement for 43D 3H to the Department of Services and Ordinances, an agreement with the combination
Pero
of
hay que
the,
decir por qué se está sacando el árbol.
yeah, I'm having trouble. That's a good idea. Very good. Help us old people out here. All right, agreement within contribution to restoration fund within 60 calendar days. Fines will be issued for failure to meet the time frame. Combination to the restoration fund equals $65 per DBH an inch. And that's my ruling. Fine.
What is your daily fine?
The daily fine will be $100 a day.
My father wishes to see if he can speak.
We did not
The father
understand.
wishes to speak.
Yes.
The ruling's been set. What
Yeah.
do you wish to say?
What do you wish to say? The ruling's been set.
Yeah, I just want to say that the reason why I take down that tree, Mr. Wayne know because he was a witness. He saw the damage that the tree was causing to my house. The tree broke all my foundation, all my water pipe, my driveway, and all that. And Mr. Wayne is a witness because he told me I'm gonna
Oh.
put that in the report, all the damage. that the
Okay,
tree is
sir.
causing to your house.
Sir, we don't need to go over all of that. What you have done is you've taken down a tree that you did not get a permit to take down.
Yeah, but
You
I
had
was
no permit.
vandalizing
I'm
that.
talking, sir. Sir, I'm talking. You had the tree taken down. You did not get a permit. If you had an arborist, the arborist didn't submit a permit. I've ruled on the case and we are through.
The people don't really care.
Next case, please.
They don't care.
So
Next case is on page 3, number 6, case number L206262. The owner is Dwayne Eugene Jones and Trudy Elaine Jones, 10619 Summer Season Place. We have service and someone is here for this case. If you're here for this case, come up now.
How do I?
Raise your right hand, please, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
Michael Schweiger, 1342 Yulee Drive, Clearwater, Florida.
I'm sorry, I didn't catch your name.
Mike Schweiger.
And what's your relation with this case?
I am
Are you
friend of the
You're representing the
Jones.
owners?
Yes, and I got a letter to that effect.
Okay.
Thank you.
Okay, officer. What would that be meant? And Ms. Hall, whenever you're ready. No problem.
Krista Hall with the Development Services Department. This is case L206262. Property owner and violator is Wayne Jones and Trudy Jones. Violation address is 10619 Summer Season Place in Tampa. It's unpermitted clearing of vegetation within a wetland conservation area. Ordinance in violation is section 4.01.03. First inspection, August 18th, 2020. First notice, August 20th, 2020. Last inspection, June 7th, 2021. 7 inspections. On August the 18th, Wayne Doyle went to the property, identified unpermitted tree debris had been disposed on the property up to about 50 feet in height throughout the wetland setback area without a permit. On September 30th, they had been working on removing the debris. They had been making a reduction to it, but not sufficient, nor restoration of the setback area. On October 27th, more debris was identified on the property. There's continued removal. January 13th, 2021, more removal of tree debris. On June 7th, the tree debris in the wetland setback area has been significantly reduced, but it's still slowly progressing. Staff recommendation at this time is remove all excess materials and restore the natural grade of the wetland setback area and to submit a wetland setback compensation planting plan for the property within 90 calendar days. Complete the installation per the approved compensation plan within 60 days after acceptance. Fines will be issued for failure to meet any of these timeframes. Note, continued operation of disposing mulch in this area will require a commercial permit.
Okay, sir, your turn.
So I guess back in a year ago, we were notified of the problem. Wayne and Trudy live on the property. They're elderly. I think they were taken advantage of they've owned the property for 50 years, and this tree stuff has been going on for well over, say, 2 decades. As soon as I found out about it, I got on the person that was doing all the individuals that were doing the work on the property, and we met at least 8 times, I guess, with Wayne and Bill Inch and Sean Burney and Bill Inch are from the EPC, and most of the property has been taken care of. The last bit is under a letter of agreement with Joe Fuentes, who did most of the leaving the tree material on the property. He has till the 23rd to meet that agreement with EPC. And he assured me yesterday that he was fully planning on meeting that. Might have already had it done. They were supposed to have had a excavator on site last Tuesday, Wednesday, and Thursday. Obviously, we had a little bit of a tropical storm coming in, and so they did not bring it to the property at that date. So it is planned to go to the property. What's today? I think Thursday is when they're going to deliver it to the property and hopefully continue the work and take everything away from the bank of the property and continue moving forward towards taking care of this. Once again, this is a decades-old problem. It's not something new. It is partially and it is by the county, the DOT. This is a very unique piece of property that sits in the middle of the county, and you'd think you wouldn't be here, but you think you'd be out in the middle of nowhere. It's a very unique piece of property. I think that Wayne can verify that we've been very, very cooperative to try and get this done. And it has not moved as fast as anybody would want it to, but it is certainly getting taken care of.
Okay, I'm ready to rule. I rule in case L206262. Based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances as listed in staff's presentation. You're to remove all excess fill materials and restore to natural grade the wetland setback area and submit a wetland setback comparison plan for the property within 90 calendar days. You're to complete the installation per the approved compensation plan within 60 calendar days. If not, a fine will be issued if you fail to meet any of these timelines. And your fine will be $100 a day. That's it.
Thank you.
You're welcome.
Turn to page 5, number 10, case number L206496. The owner is Li Yao Zing, 1002 Coretto Avenue. We have service and we have someone here for this case. Good morning.
Good morning.
Can I give you the oath of witness?
Oh, yeah, sure.
Okay. Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And now I'm going to need both of your names and addresses for the record.
Okay. George Way, 1002 Coretto Avenue, Brandon, Florida, 33511.
Li Yao Zheng, 1002 Corrido Avenue, Brandon, Florida, 33511.
Okay, thank you.
Ms. Hall, whenever you're ready.
Krista Hall with the Development Services Department. This is case L206496. Property owner violator is Li Yan Zing. Violation address is 1002 Coretto Avenue at Brandon. Violation observed is the required street trees are deficient for La Colina subdivision. Ordinance violated is section 6.06.05. First inspection, December 29th, 2020. First notice, January 11th, 2021. Last inspection, July 8th, 2021, 2 inspections. The inspector, Tony Hood, went to the property. This lot requires 3 street trees. These trees were trimmed and does not meet the standards of a street tree for Hillsborough County when it's excessively pruned in this manner. Tony Hood is online to assist on any of these inspection reports. Moved back to the property in July. Trees were retrimmed again, does not meet the county standards for trimming, and the street trees are deficient per the code. They'll need to replace the street trees with trees that meet the street tree requirements. Under the code, they can install 3 new types of street trees at the standards of the LDC Street Tree Section 6.06.05B. And failure to install proper street trees will, fines will be issued for that.
Okay, you said there's an inspector online. Does he need to add anything to this?
Hello. So during the investigation, I found that the 3 street trees were pruned improperly, which constituted as an effective removal.
Okay.
I'd like to add that he had a certified arborist review these trees and confirm that these trees did not meet the standards of pruning and for the street tree requirements.
Okay. All right, which one of you gentlemen wants to be first?
So we received the notice on January 11th. It was our understanding that we didn't have enough trees planted, so we actually added 2 more trees. And we emailed the HOA on January 29th, and we were declined approval for planting on March 8th. We went back and forth with the HOA a few times and finally got approval on June 25th, which then we proceeded to plant 2 magnolia trees to meet the code.
If they have 3 street trees that meet the code requirements, we can approve of it. Since we've given them 30 days, that gives us time to inspect before or change the trees beforehand. Okay?
Okay. All right, so you say you've put your trees in.
That's correct. So
Okay.
according to our HOA, they said that we could either have the street trees or 2 trees on the property. So we actually added to the southern magnolia trees to our property.
Just to let you know, that lot requires 3 street trees, so you'll need to have at least 3 that meet the county standards, not 2.
Oh, it's Sangam. On the third tree, it wasn't on the original, I guess the lot survey that was provided by the builder, because these were all new build homes. And only 2 trees, let me see, I have the boundary survey here. And it didn't show that we were supposed to have another tree, so is this something that we should contact the builder for?
You could do that if the builder wants to help you, but the county code for
Okay.
that subdivision requires 3 trees for that lot.
Okay, so we need 1 more street tree? Is that?
Yes, sir.
Okay.
Okay, I'm ready to make my ruling. Case number L206496. Based on the evidence presented, I find the property is in violation of the Hillsborough County Code of Ordinances as listed in staff's presentation. I need staff's presentation up there, please.
Yeah, where did it go? There it is.
Okay, you're to install. Make sure you have installed 3 street trees within 30 calendar days. Street trees must meet the standards of the LDC Street Tree Section 6.06.05B. It will be $100 a day will be the fine that will be issued if you failure to meet this time frame. Next case, please.
Okay, I just had a quick question. Where can I get a copy of the street tree requirement? So we can make sure we plant it according.
Ms. Hall, where would he be able to get a list? Would that be,
It's on the county website, but you can also contact the inspector and he'll send you one too.
Okay.
And it was included in your first notice.
In the first notice?
Yes, sir.
Okay.
all right, next case, please.
Turn to page 8, number 15, under right-of-way cases. We're about to have a computer issue. Can we have a recess? Oh.
We're going to be in recess for about 15 minutes.
Solid. Something. What do I have to? Yeah, we're not going to go there yet. These two? No. H6. These two, yeah. Sammy, I saw that name and I didn't mark them for some.
attention, everyone. The meeting will resume in 3, 2, 1.
Okay. Case are we on?
Turn to page 6, number 12. Case number L216634. The owner is Sammy Herrera. And the property is a vacant lot besides 4504 South 22nd Avenue. We have service and we have someone here for this case. If you're here, come up.
Morning, my name is Sammy Herrera.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, and now your name and address. I got your name already.
I try to speak perfect English. I don't speak perfect English. My brother, every time my brother Gabriel, he speak for me.
Is he here?
With Miss Hall and different people of the county.
Is your brother here?
No, he working right now. I try to understand perfect, I try to be the best,
We have anybody that speaks Spanish that would like to interpret for this gentleman? All right, I'm going to continue this case then. Oh, you can speak Spanish? Come on then.
Thank you, gracias.
Creo que necesita.
No, esto que está aquí, que me enviaron esto, y yo quiero saber.
He received a letter.
No,
Okay,
it's not your time.
Wait, just
She
a
needs
minute.
to swear you in.
He took his oath. Can you, and I'm sorry, we have to have you put your masks on. I'm sorry. Come over to where you, near the microphone.
He have a letter.
It's not time for that yet.
Just a minute. We're going to let you talk in a minute.
Okay.
Can you identify yourself, sir?
My name is Jose Mendez.
Okay, and raise your right hand so I can give you the oath. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And since you're translating for him, it won't be your testimony, just that you'll translate truthfully and to the best of your ability. Thank you.
Okay, officer. Or Ms. Hall.
Good day. This is case L216634 from Krista Hall with the Development Services Department. The property owner and violator is Sammy Herrera. Violation address is 4504 South 22nd Avenue in Tampa. Violation is noncompliance with the Natural Resources Permit NRO 48350, Special Conditions 1 and 3, and Standard Condition Number 2. The ordinance violated is Section 4.01.14. First inspection is February 18th, 2021. First notice, March 10th, 2021. Last inspection, June 28th, 2021. 4 inspections. This is a copy of the permit that was issued to Mr. Herrera for the property at 4504 South 22nd. He was authorized to clear vegetation and fill historic ditches with historic fill piles and a maximum of 215 cubic yards. It was approved to do, let's go down to the conditions. 1, code enforcement case 205968 at that time required a planting of 52 inches of replacement trees and 8 palm trees by a plan that Mr. Nick Quilling submitted on September 20. And condition number 3 required that these trees be installed within 90 days from issuance date of the permit. That has not happened. The pictures were taken on
Papeles y todo para sacar todo el ley y todo.
on February 18th.
No, el arquitecto estaba bregando con los permisos de todo eso para poder poner lo que va a poner y después los palos.
Do you need time for me to translate that last slide?
I can translate it now. Oh.
Okay, the pictures taken by John Beavers shows the property was cleared. There's no additional trees added to the property. Everything has been conducted. Standard.
Sí, pero yo pagué una multa de $1,550 que yo pagué para remover unos árboles.
Are you ready for this slide? Okay, this is continued page 2 of the permit. in which standard permit condition number 2 required protective tree barricades as approved by the department be maintained throughout the course of construction. The failure to maintain the tree barricades will be a violation of the code. As you can see in the picture before, there is no tree barricades around any of the trees. And as you look, their trees have been removed. There's no barricades shown in this picture back in February.
Ya estaba el permiso supuestamente porque yo pagué una multa de $1,550 para yo poder remover unos árboles.
And then on June 28th, most recent inspection, there is some silt fencing up around. That is to protect the wetland areas. But there is no tree barricades around any of the trees. And no new trees have been put on the property in accordance with permit condition number 1. So the county's recommendation is restore the tree barricades around all existing trees within 30 calendar days. Finalize the permit conditions number 1 and 3 within 90 calendar days. And fines will be issued for failure to meet these timeframes. Do you need me to go back on any of these slides for translation?
You've translated everything
but-
that she has said.
Yeah, what he said that he paid a fine for $1,500
Son $50
and 50
for remove couple
for removing the trees.
of trees. Yes.
Okay, if you look at this page, you'll see the permit. Permit condition 1 says there's a requirement for planting 52 inches of trees and 8 palm trees. Condition number 2 says an additional 27 inches of trees or a payment into the fund. You did make that payment. So you did resolve condition number 2, but you never did number 1. Number 1 does require tree plantings.
Que planten los árboles.
Sí, no, yo voy a plantar los árboles, pero el arquitecto está bregando con el plano. ¿Dónde quedan?
He says that he's working on it because he contract an architect to he's in the process.
To all the process.
That's what he is telling me. He's in the process to do that.
Okay.
Let me go back to that. Okay. There you go.
Okay, I rule in case number 1216634. Based on the evidence presented, I find that the property is in violation of Hillsborough County Code of Ordinances as listed in staff's presentation. The order is to restore tree barricades around the existing trees within 30 calendar days. Finalize special conditions of 1 and 3 within 90 calendar days. If not, a fine of $100 a day will be assessed.
Dice que,
Esas son las que tengo que seguir, esas directivas.
dice que tiene que pagar 100 pesos por día si no lo hace en 30 días.
Okay, está bien.
Okay?
Yes, sir.
Don't go away. The next case is yours too. Okay. Next case is number 13L216646. The owner is Sammy Herrera. Location 4504 South 22nd Avenue. We have service and Mr. Herrera is here.
Otra evaluación.
Ms. Hall? Okay, take your time.
¿Qué hiciste ahí?
Krista Hall, Development Services Department, case L 216646. Property owner and violator is Sammy Herrera. Violation address is 4504 South 22nd Avenue in Tampa. Violation is unpermitted disposal of field materials located within a 100-year floodplain. This is the lot that is right next to the one that this is permitted. Unfortunately, he did not put this folio on that permit, so we cannot call this a permitted activity. So the ordinance in violation is section 4.1.03. First inspection was found on February 16th, 2021. First notice, March 17th, 2021. Last inspection, June 28th, 2021. 4 inspections. This is the map that shows where this lot is located. It is in the FEMA flood zone, has an AE, requires a permit for any filling activity that occurs on this property. February 16th, John identified that another lot was being cleared. He checked and confirmed that it was not part of the permitted area. As you can see, a lot of trees were being removed. June 28th shows that the lot is still in a cleared condition.
Permiso está al revés.
No permit has been issued for this lot.
¿Tiene permiso usted?
El permiso está al revés. El permiso, el de este lado.
John Beavers is online if you need any questions for the inspector. But staff recommendation at this time is either remove all of the fill materials that's disposed in the 100-year floodplain within 90 calendar days, or submit the required information for a natural resources permit application and finalize the requirements of the permit within 90 calendar days, which includes submitting a professional engineer's plan and an as-built plan of the final grade elevations. Fines will be issued for failure to meet these timeframes. Is there any slides you need me to repeat for translation?
Okay, your turn, sir.
El permiso de la propiedad del frente es el permiso de atrás. Estaban confundidos por 4 o 5 meses o más con una construcción que había al frente. Pero el permiso que está al frente es el otro permiso de al lado. El del frente no tiene permiso. El del frente estaba limpio ya. Es el de atrás.
He said that there's like a house in the front and then the front to front. And there was the permit was for one side and there was on the other side. I don't know, make no sense to me, but that's what he said.
The permit is not for the front, it's for the back. He confused because the permit is for the back. For the second property he showed me, not for the first one. I don't know what's going on right there. And the people go and check a couple of times.
So what you're trying to say is you do have the permit for both sides.
El permiso
Del otro lado.
de un lado,
No, he said that he had only permit for one,
pero todo es una pieza completa al arquitecto.
but there's a whole piece and he just got the permit for one side and not the other side,
Because the other side is clean,
because the other side was.
yeah.
All right, I'm ready to make my ruling. I rule in case L 216646. Based on the evidence presented, I find that the property is in violation of Hillsborough County Code ordinances as listed in staff's presentation. You're to remove all fill material within the 100-year flood plan within 90 calendar days, or submit the required information for a natural resource permit application and finalize the requirements of that permit within 90 calendar days, which includes the following items must be included in the application. Submit a professional engineering plan, provide an as-built plan for the final grade elevation. If you fail to do so, within 30 days, you'll be fined $100 a day.
Yo hablo con el arquitecto, el arquitecto llama a Togel.
Sí, estoy en el mismo problema.
That was 90 days, not 30 days, right? On the recommendation.
Sure, 90 days,
90, okay.
30 days in the other one and 90 days in the other.
$100 a day.
100 pesos a día.
Okay, next case.
And I will get the orders translated into Spanish for him.
No, I understand. He explained it to me.
I already explained it to him.
Okay.
Thank you. Appreciate it.
Now turn to page 8, number 15, case number ROWV-21001. The owner is Jose Luis Mendez, location 6809 Gunlock Avenue. We have service and Mr. Mendez is here.
That's me.
Do you swear or affirm the testimony you're about to
Yes,
give
ma'am.
will be the truth, the whole truth, and nothing but the truth?
Yes.
And now state your name and address.
Okay, my name is Jose Mendez, and I live in 6809 North Ground Lock Avenue, Tampa, Florida, 33614.
Okay, and Ms. Baker will present her side of the case first.
Okay.
Thank you. This is Vicki Baker, Engineering Associate Supervisor for the right-of-way Public Works Construction Services section. If you could put the slideshow up, please.
I can hear you. Clear.
Can you hear me, Magistrate? Okay.
You can hear me now?
All right, thank you. Thank you. The owner is Mendez Jose Luis. The violation address is 6809 North Gunlock Avenue. The violation observed was work done within the right-of-way without a permit.
Yes.
The ordinance sections violated is Hillsborough County Section 9222 of ordinance and Section 2.5 Utility Accommodation Guide and Rights Away Use Procedures Manual. The first inspection was conducted on June 9th of 2016.
Yes, ma'am.
A first notice of violation sent on September 13th of 2016. A
Yes.
second notice of violation was submitted and mailed in September 10th of 2019. And then the last inspection was done on July 12th of 2021. The
Yes.
total number of inspections of 4. Next
Yes.
slide. Next slide, please. This is existing conditions of the property back in September of 2000, or excuse me, June of 2016, showing the ditch in place with subsequent mitered in sections, which accommodates road runoff and lot runoff. Next slide. The inspection was done again June 9th, 2016 by Orlando Obain, and showing the front of the property has been completely filled and the without any permitting in place. Next slide. This is a photograph from the last inspection of July 12th of 2021, showing road runoff staging in the right-of-way due to the infraction. Next slide. Just again showing, this is after rain event at the address. And the last slide for the photographs would be that mitered in section on the northern side of the residence, showing flow going through the pipe. Status. Next slide. And the last photograph showing no activity since the 2016 initial inspection. And staff recommendation slide, please. Staff recommendation would be to coordinate with staff and complete the right-of-way permitting that is needed for option 1 or option 2, which is stated below. Option 1, remove the 15-inch plastic pipe and restore the ditch as before to original condition. Or option 2, keep the pipe and provide FDOT Class C DBI, which is ditch bottom inlet, with shallow swale on top to capture the flow of water. Also, you must secure the above joint with a concrete collar. And if this choice is elected, you must provide a proposed plan for further review to Development Services. All items need to be resolved within 30 days. These two options were referenced in his second notification, notice of violation in September of 2019.
Okay, so I have this straight.
Yes.
He just put a pipe where the ditch was. Let me finish, sir.
Sure.
He put a pipe where the ditch was, and it is not approved.
That's
The
correct.
pipe or the covering of the ditch, or just the pipe?
The pipe and the covering the ditch.
So he will have to either do one of the two options that are stated in the recommendation.
Okay, I got it. Go ahead, sir.
Yes, well, the reason maybe sounds like illogic or stupid in another way, but I don't know that I had to have permission for that. By that time, I'll have problems with my septic tank, which is how I want to put it in the back. So the person, the people that they are contracted for the septic tank, they had to build like a road to go in the back to the house to put my septic tank. And now sounds like, maybe like I'll say it sounds stupid, but I was like, well, we don't just cover that whole thing. And he said, yeah, okay, but I don't even know that I had to get a permit for the city once. And second, he used the right material and all that because of a couple inspectors, they show up and they don't see no flood, they don't see anything. And by the way, right now I'm in the process, but this been in the process in May 21, they get a contractor to do the right thing because they said they either they had to put or remove the pipe or do an inlet between I don't know what, and this is how they're gonna do it. And this in the process because the storm and all that stuff. I contacted him yesterday. He told me that they're building the concrete box, which is just gonna be put it on back on like do it the right way, I guess.
Okay.
And I got all the information for the contractor and everything.
If you can put the recommendation back up for the magistrate, please.
So you've already got somebody to do this?
Yes,
work, is what
yes,
you're
sir.
telling me. Okay,
Yes, sir.
all right.
And they will be done. I mean, just because the storm, they should be already done, but they said everything is backed up doing stuff and so, but this already in the process to
Okay.
any day.
All right, I rule in case ROWV 21001. Based on the evidence presented, I find the property is in violation of Hillsborough County Code or ordinances as listed in staff's presentation. Coordinate with the staff and complete the ROW permitting that is needed for either option 1 or option 2. Option 1 is to remove the 15-inch plastic pipe and restore the ditch as before in original condition. Or option 2, keep the pipe and provide FDOT type CDBI, whatever that is.
It's a type C FDOT structure, a ditch bottom inlet.
Okay. What she said. Shallow. To capture the flow. Also, you must secure above joint with the concrete collar. If you choose to elect, you may provide a proposed plan for further review. Okay, these items need to be resolved within 30 days. If they are not resolved within 30 days, a $100 fine will be assessed.
No problem.
Okay, so stay in touch, 30 days, or you're going to start being fined, okay?
Yes, sir.
Thank you, sir.
Thank you.
Next.
Next case is number 16, case number ROWV-21002. The owner is La Nina Enterprises LLC, 5806 North Lincoln Avenue. We have service and we have a party here to speak. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your name and address.
Ramon Niebla, 3119 West Idlewild Avenue, Tampa, 33614.
And are you the owner of the company?
Representative.
Okay, thank you.
Okay. Who's given this one?
I'll be giving this one as well.
Go ahead.
This is Vicki Baker, Engineering Associate Supervisor for the right-of-way section, Public Works Construction Services. If you could put up the slideshow, thank you. This is in case ROWV-21002. Owner is Lalina Enterprises LLC with a violation address of 5806 North Lincoln Avenue. The violation observed is the new installation of driveways and substandard pipe without a permit, obstruction of vehicle visibility. Ordinance sections violated are Hillsborough County Section 92-22, Section 2.5 Utility Accommodation Guide and Rights of Way Use Procedures Manual. The first inspection was conducted on June 26th of 2020 by Patrick Ayala. First notice sent on July 23rd of 2020. Last inspection was conducted on July 12th of 2021. Total number of inspections of 5. Next slide. This photograph is of the unpermitted driveway that was installed along West Clifton Avenue, which is along the backside of the property. Next slide, please. And that's the second inspection that was done after the driveway was installed, and the notice of violation had gone out. It's at the same location along Clifton Avenue, which is at the rear of the property because this is a corner lot. Third slide. And then this is a photograph that was taken on July 12th of 2012. And as you can note, along the front, along the pavement side, that apron at the corner is already starting to deteriorate due to the insufficient depth of concrete, which is a code violation. Next slide. The slide was taken on the initial inspection from Mr. Ayala, and this shows that a front driveway and sidewalk that's put in place along Lincoln Avenue, which is the address of the violation. Next slide. This slide shows a later inspection after the concrete was installed and the notice of violation had been sent, showing the completed work. Next slide. This is a view along Lincoln at the front of the property showing the connection to the edge of pavement and the driveway in place within the radius of Clifton, which is a code violation. Next slide. This photograph shows the inspection from July 12th of 2021, and the resident has, or property owner has installed a fence, a 4-foot chain link fence, or appears it's not a chain link, but a picket fence across the drive indicating no parking, and which is a violation. Next slide. The right-of-way dimension for Lincoln Avenue is 60 feet. This fence, this is looking northerly. This fence is located within the right-of-way now. It's in front of the sidewalk and it encourages within the right-of-way. And to the left, you also see, looking south, the fencing that's in place across the driveway with the no parking signs. Let's go to the staff recommendation. Coordinate with staff and complete the right-of-way permitting that is needed for the new driveways. Removal and replacement of culvert and driveway apron along Clifton Street. Removal of driveway apron to right-of-way line along Lincoln Avenue is necessary since the apron is too close to the street point of curvature. Minimum 10-foot setback is required by code. Removal of newly installed fencing across front of property due to a right-of-way encroachment and obstruction that's been created, removal of the sidewalk that attaches to the edge of pavement mid-block connection is not allowed. It's a safety issue. And all 9 items need to be resolved within 30 days.
Was he given a notice before he finished this? There was like 5 notices, but it wasn't showing me in sequence.
The initial inspection was done on June 26th, and then subsequently July 23rd, the notice went out, notice of violation.
But it had already been done.
That's correct.
Okay, thank you.
Yes, sir.
Sir, go ahead.
Yeah, once we got the notice, it was already poured. Then I tried back and forth with several companies to do different things there to correct that. So at this point, I'm just looking to see what I got to do to move forward. But I didn't know we were in violation for the property, the driveway on Lincoln. They had always told me the one on, I'm sorry, not Lincoln, on Clifton. They had told me the front property on Lincoln was the one that I would have to block it off or do something so cars don't park there. Because that culvert pipe that's on Clifton, that was always there. We didn't install that. We didn't touch that. It's still buried underneath the dirt, but we never cleaned the ditch or nothing out.
Okay, so which driveway, or are we talking about both driveways?
We're talking both driveways. When the driveway is installed, you must bring everything up to Hillsborough County standards. And that existing culvert is a substandard sized culvert. So that would need to be evaluated. That's why we have the permitting process.
Okay.
The second driveway, of course, there was never a driveway in doing historical review. There was never a driveway for that residence along Lincoln Avenue because the rear building was always a garage. So the rear building always appeared to be from the photographs and from historical data, it appeared to be just a haphazard driveway with stabilized material, never had an apron or a concrete drive. That was the access for that particular property. When you have a corner lot, there's a lot more conditions that are taken into effect. And then placing a driveway on Lincoln within that radius creates a safety hazard. We've had numerous complaints from residents regarding close calls for traffic because the individual traveling on Clifton would have to inch out if there's an obstruction in the driveway because it's so close to the intersection. So it creates a site triangle dynamic.
Okay. Okay, I'm ready to rule. I rule in case number ROWV 21002. I find that based on the evidence presented, the property is in violation of Hillsborough County Code of Ordinances as listed in staff's presentation. You're to coordinate with the staff and complete the right-of-way permitting that is needed for the new driveway. Removal and replacement of the culvert and the driveway apron along Clifton Street. You're to remove the driveway apron on the right-of-way line along Lincoln Avenue is necessary. The apron is too close to the street point of cover. 10-foot setback is required. Removal of a newly installed fence across the front of the property is on the right-of-way and the obstruction. It must be removed for the sidewalk that attaches the edge of the pavement. Mid-block connection is not allowed for safety reasons. These items need to be resolved within 30 days. If they're not resolved within 30 days, a $100 fine will be imposed.
Okay.
Okay.
All right. Thank you.
You're welcome. Next case, please.
Okay, that I believe concludes any audience members, and that does conclude the right-of-way cases as well. So turn to the beginning of your agenda. Page 1, number 1, under water ordinance cases. Case number WR 2100167. The owner is Calvin E. Bailey, 10310 Carlaway Hills Drive. We have service and no one is present.
Do we have somebody testifying?
No, there are no other citizens.
Says Carmine Pisano. Okay, go ahead, sir.
Well, I didn't think you meant him.
I am Carmine Pisano with Code Enforcement. The first case is WR 2100167. Ordering violation on Thursday, 2/18/2021 at 8:28 a.m. in the morning. Officer Ted Baker arrived at the location of 10310 Carlaway Hills Drive to find the sprinkler system on along the rear of the property. This is a non-watering day and it was just outside the watering hours. This location is south of the Alafaya River where there is a 2-year one-day watering restrictions placed on the area. A notice of violation was mailed out on 2/22/2021, followed by the default letter mailed out on 3/31/2021. And the notice of hearing was mailed on 5/20/21. This is a second event at this location. The first event on 1/29/2021 was a watering violation courtesy letter, and the fine for this incident is $100.
Okay, ordering case number WR 2100167. Based on the evidence presented, I find the property is in violation of Hillsborough County Code or ordinances as listed in staff's presentation. I order that the amount of fine of $100 be paid within 30 days. If it is not paid within 30 days, an additional $50 a day fine be assessed.
Next case is number 2, case number WR 2100187. The owner is Wilson Preserve Community Association Incorporated, 10207 Summer Azure Drive. We have service and no one is present.
This is Carmine Pisano once again with Hillsborough County Code Enforcement. This case is WR 2100187. This deals with the common area of the Wilson Preserve community. They use a business address of 10207 Summer Azure Drive. As you can see from the photographs, on Wednesday, 2/24/2021 at 7:12 a.m., Officer Ted Baker arrived at the location of Wilson Preserve community to find a sprinkler system on along the center island and a broken sprinkler line at Capillary Court. This is a non-watering day during non-watering hours. The location is also in the special area of south of the Alafaya River. Notice of violation was mailed out on 3/2/2021, followed by a default letter on 4/9/2021. Notice of hearing was mailed out on 5/20/21. The first violation was on 1/29/2021, where a watering violation courtesy letter was sent. And it actually was another one on 1/30/2021, where again resulted in a courtesy letter on back-to-back violations. The fine for this offense is $100.
Okay, I rule in case WR 2100187 that the fine of $100 be paid within 30 days. If it is not paid within 30 days, a fine of $100 a day be assessed. Next case.
Number 3, case number WR 2100257 is pulled for lack of service and will be rescheduled for a future hearing. Page 3, number 7, case number L206347. The owners are Do Win and Kong Plee and Thai 5131 Countryside Drive. We have service and no one is present.
Krista Hall with the Development Services Department. This is case L206347. Property owner and violator is Do Q P Nguyen Dai Tu Lee Guang. Violation address 5131 Countryside Drive, Tampa. Violation observed, unpermitted removal of one laurel oak tree measuring 52 inches DBH at a diameter of 4.5 feet. Ordinance violated section 4.01.03, first inspection October 1st, 2020. First notice October 13th, 2020. Last inspection July 7th, 2021, 3 inspections. As you see, there's no tree on the property that was found on October 1st. And we've been working with Mr. Gwynn in regards to planting trees, and he planted 3 trees and they did not survive, so we could not give credit for dead trees. So staff's recommendation is that he submit a final contribution agreement for 52 inches of trees to the Development Services and complete the restoration agreement or the contribution to the Restoration Fund within 60 calendar days. And fines will be issued for failure to meet that time frame. The last time I talked to him earlier this week, or last Friday actually, was that he was going to make a payment. So hopefully we'll have that done within that 60 days.
Okay. I rule in case number L206347 that a submittal of a complaint, tree restoration and or combination agreement of 52B DBH to the Development Services and complete the county restoration agreement and or combination of the restoration fund within 60 calendar days. Fines will be issued for failure to meet the time frame, and that fine would be $100 a day. Next case, please.
Page 4, number 8, case number L206423. The owner is Marcio Vieira. The location is a vacant residential lot, Odessa, west of 8643 Gun Highway. We have service and no one is present.
Krista Hall with the Development Services Department. This is case L206477. Property owner violator is Smart Communication Holdings LLC. Violation address is 1 Riverview, south of Dixon Drive. Violation observed is 1, an unpermitted removal of 3 laurel oak trees measuring 54 inches DBH at diameter at 4.5 feet. B, unpermitted grading and filling on the property that alters the surface water flows. Ordinance violated is section 4.01.03. First inspection is December 17th, 2020. First notice to February 16th, 2021. The last inspection, June 25th, 2021, 2 inspections. First inspection that was done was on December 17th, 2020, taken by Tony Hood. He attached a picture that was in the property appraiser's file that showed you what the property looked like before the property owner took over. And this property owner on December 17th, you can see what he started doing. He started filling all of the property. On December 17th, 2020, Mr. Hood went to the property again to and show that the property was continuing to work. We got numerous complaints about the activity, about the tree clearing, about the filling that has been going on the property. And we went out there and issued a cease and desist on the property. December 17th, for more pictures of the activity. June 25th. The property is being leveled. There's materials being dumped on the site. That looks more like illegal dumping since it's not suitable materials. Staff's recommendation at this time. Oh, great. Where'd it go? Back to it. Is to submit a compliant tree restoration and/or contribution agreement for 54 dB 8 inches to the Development Services Department and complete the county restoration agreement and/or contribution to the Restoration Fund within 30 calendar days. Also submit a natural resources application within 30 calendar days to address the disposed fill materials and stormwater requirements for the land alteration activities. Obtain the natural resource permit and finalize the requirements of the permit within 60 calendar days. And a fine will be issued for failure to meet these timeframes. So
Okay, go ahead.
just to maybe simplify it, we need a tree restoration plan within 30 days and a permit application within 30 days. And then to finalize all the permit requirements in 60 days. We didn't want to put it all in one time frame because we need to get the plan started in regards to what they're going to do for restoration.
Okay. I'm ready to make a ruling, and it's going to be a 2-part. Part 1 is they're going to submit a compliant tree restoration and/or contribution agreement for 54 dBH to the Development Services and complete the county's restoration agreement and/or combination for the Restoration Fund within 30 calendar days. They're also to submit natural resource application within 30 calendar days. This will address the disposal, fill, and stormwater requirements for the land alteration activities. Part 2 is going to be they're going to obtain a natural resource permit and finalize the requirements of the permit within the 60 calendar days. Fines will be issued for failure to meet the time zone, and the fine is going to be $500 a day past the 60 days.
Next case is number 9, case number L206477. The owner is Smart Communication Holdings LLC. Location is a vacant lot, South Riverview, Sims Road, and Highway 301 area. We have service and no one is present.
That's what I presented with Smart Communications.
I had a feeling something was not right. I did not catch that.
Did I read the right case?
You
The case number, did I read the correct case number?
If you read off my screen, you did.
Have them check that later and
Okay.
subscriber and make sure
Okay.
that the case number does match.
So the order that you just gave, you want it for L206477 Smart Communications,
I want
correct?
it For the one, yes, that was shown on the screen.
Okay. Okay. I guess we can do that.
So the one that got skipped was the Vera case?
That's the case I called.
Okay, my apologies. Let me,
Let's get these two right, because now I'm confused. Are we good?
Good, I'm going to call the other case. We will go back now to number 8, case number L206423, Marcio Vieira, vacant residential lot, Odessa, west of 8643 Gun Highway. And we have service and no one is present.
this is Krista Hall with the Development Services Department, case L206423. Property owner violator is Marcio Vieira. Violation address is east of 8643 Gun Highway, Odessa. This is unpermitted land alterations and disposal of fill materials that alter surface waters in the area. Violation ordinance violated is section 4.01.03. First inspection, November 18th, 2020. First notice, December 7th, 2020. Last inspection, June 7th, 2021. 3 inspections. On this property, Mr. Doyle, the inspector, was out on the property, identified an unpermitted fill, and unauthorized fill debris was disposed on this property without permits. Portion of this property is in a floodplain, but it could not confirm the location of fill had gotten into the floodplain. Looks like it's not out into it. On November 17, 2020, Mr. Doyle went back to the property. I found that, I don't know if you can see, there's some dark piles. They're kind of blending in with the wood, but there's still debris out there. Actually, it's fresh debris. There on June 7th, he still finds that the debris, fill piles are still on the property. Staff recommendation is that the property owner submit natural resources application and obtain a permit after receipt of application within 60 calendar days. This will address the disposed fill materials or remove all fill materials from the property within 60 calendar days. And fines will be issued for failure to meet these timeframes.
Okay. I rule in case number L206423. Based on the evidence presented, I find that the property is in violation of Hillsborough County Code of Ordinances as listed in staff's presentation. They're to submit a natural resource application and obtain permit after receipt of application within 60 calendar days. This will address the disposal of fill materials or remove all fill materials from the property within 60 calendar days. If it's not done, a fine of $200 a day will be assessed. Next case.
Page 5, number 11, case number L216601. This case complied July 12, 2021. Page 7, number 14, case number L216686. The owner is Ferris and Peggy Waller, and the location is a vacant residential lot west of Paul Buckman Highway. We have service and no one is present.
Krista Hold with the Development Services Department. This is case L 216686. Property owner and violator is Ferris Waller and Peggy Waller. Violation address west of Paul Buckman Highway and south of Joe McIntosh Road in Plant City. Violation is unpermitted disposal of fill materials within a 100-year floodplain area. Ordinance violated is section 4.01.03. First inspection is February 24th. 2021, first notice, February 25th, 2021, last inspection, June 3rd, 2021, 5 inspections. This is a aerial picture of the property, identified the FEMA flood zone area, which is in the darker blue. The black circle is trying to show the area where all the fill was disposed. It's not completely in that circle, but it's pretty much randomly in that area. You'll see better in the next photo. On February 23rd, Wayne was on the property. He identified unpermitted fill that was disposed over 8 feet high and approximately 300 feet long. He also noted an area that was about 8 feet high, 300 feet long. In June, the property hasn't changed. The fill materials are still in the floodplain area and grass has grown over it. Staff's recommendation at this time is remove all fill materials from the floodplain area within the next 90 calendar days or submit the required information for a natural resources permit application and finalize the requirement of the permit within 90 calendar days. Following items must be included in an application for filling in a floodplain. Submit a professional engineer's plan or certified floodplain manager's report. Provide an as-built plan at the final grade elevations. Fines will be issued for failure to meet these timeframes.
Okay, I rule in case L 216686. Based on the evidence presented, I find that the property is in violation of the Hillsborough County Code or ordinances as listed in staff's presentation. They're to remove all fill materials from the floodplain areas within 90 calendar days or submit required information for a natural resources permit application and finalize the requirements of the permit within 90 calendar days. The following items must be included in the application. Submit a professional engineer's plan or a certified floodplain manager report. Provide as-built plan for the final grade of elevation. This is not done within the 90 days, a fine of $100 a day be assessed. Next case, please.
That concludes the agenda.
Unless anybody has anything to say, we're adjourned.